Hello, everybody. My name is Juan Carlos Brando. Thank you so much for joining us today in this show with one of the attorneys in the law firm of Margaret W. Wong and Attorney and Associates. And well, today is a good time for us to talk to the attorney that is an expert in the immigration field, also working with asylums, working with cancellation of removals and waivers, which is one of the most important parts of what the attorneys can do in the immigration field. So being an attorney is not just filling out forms, is knowing how to fill out a form, is knowing how to do the job, what to do or what to say when you go to court, and that's one of the things that you need to know. If you find someone that is not an attorney to fill out your documents, if there is a problem, you will not be represented in front of any immigration uh, office or immigration court. So that's why you need an attorney to take care of your case. We know that there's a lot of paralegals that are independent or associations or uh, companies that try to help people with their immigration applications. But if there is a problem, they're going to tell you there's nothing I can do for you. I did what I had to do. And then you need to find an attorney to defend you in this case. And that's why you need to only call an attorney. It may look more expensive than a paralegal, but guess what? At the moment that you have to go to court, your case may be paid off, or your case may be just a little debt in it, or you know that you're going to be represented no matter what. But if you don't have an attorney and you file your application without an attorney, if you have to go to court, before going to court, you're going to have to find an attorney, and probably you're going to have to pay the whole amount at one time before going to court. So there's a lot of advantages of talking to a real attorney in the United States based on the immigration field, and that's what you need to do. You need to talk to an attorney. I don't want to put shame on anybody else. Everybody is doing a good job or trying to do their best. But my recommendation is if you need immigration advice, talk to an immigration attorney. Today we have the attorney Kwasi Bediako, who is one of the attorneys in the law firm of Margaret W. Wong. Hello, Attorney Kwasi. How are you doing today?
Hello, Juan. I am well, thank you. How are you?
I am doing good. I'm just trying to give people some advice about why do they need an attorney, especially for asylum applications. Or, I mean, there are some applications that look easy, but especially asylums or waivers uh, that are applications that really need the knowledge of what you are doing. But what happens if a waiver is denied, or what happens if the asylum is not granted in the immigration office?
Thank you, Juan. So, to begin with, it's really important that you use an immigration attorney in all your cases because attorneys don't, as Juan mentioned, they don't just fill out forms. Attorneys, we strategize. Okay, so an attorney kind of looks at the case from the start. So when you go to an attorney, you look at it and say, okay, here we are. You've been here from, let's say, you've been in the U.S. for 6 months. Okay, if we file your case within the next 1 year, what should we expect? Are you in proceedings? Are you not in proceedings? Does your case go to the USCIS? Does it go to the court? These are all things that an attorney would know. I've had instances where clients will reach out. Oh, they had a paralegal. They had an immigration consultant that was helping them, and that consultant didn't even know that if a notice to appear, which is a charging document, usually when you come to the border and they give you a charging document, once that has been filed with the immigration court, you cannot file the asylum with the USCIS. And this was someone who was working with what they claim to be an immigration consultant. So one, it's important that you have a lawyer because the lawyer knows where the traps are. The lawyer knows how to avoid mistakes, costly mistakes. This person was right on the border of hitting that 1 year, because usually you have to file an asylum within 1 year. And had that person not come to our office, they probably would have missed it, because they would have filed the case with the wrong office, and then it would have been rejected, would have gone over the 1 year, and then he would have no longer been eligible to apply for asylum. So this is just one instance of when you need to speak to an immigration attorney. They know the differences, they know the nuances, they know the little things in the law that a regular paralegal or a consultant would not know. And so now to your question for asylums, what happens if an asylum is denied? Okay, so there are two ways where you file an asylum. So they have the affirmative asylum, they have the defensive asylum. Affirmative is when you come, let's say you come to the US with a visa, you're here in the US, within 1 year, you realize, I have a fear of going back, so I'm going to file an asylum. In that case, you file it with the USCIS. Okay, here you file with the USCIS. They'll schedule you for a fingerprint. You go get your biometrics done. The case will pen for a couple years, and then they'll schedule you for an interview. And then there's the defensive asylum, which is where you are in proceedings. Okay, let's say you come across the border. They issue you a charging document, which is the notice to appear, or in short, the NTA. So you're in proceedings, and you file it to defend yourself. It's a defensive filing, where you file it with the immigration court. So here, instead of going to the USCIS, here a judge will be the one reviewing it. A judge will be the one making a decision whether to grant it or not. Either ways, we'll start. If you're with the USCIS and your asylum, your 589 application gets denied, it will be referred to an immigration court. So if you come to the US, you're not in proceedings, you've not been issued a charging document or a notice to appear, you will file your asylum with the USCIS. Generally, as at now, they have a lot of backlog, so it's taking about 6, 7, 8 years, sometimes more. After that, you go for the interview, and if they don't grant it, they will send it to an immigration court, where it would be assigned to an immigration judge, and then you would have to go to court, and there you would be in what we call removal proceedings. That's where the judge will review the application. Hopefully, you have a lawyer. They'll set a hearing date where you will appear with your lawyer. They will take testimony. They will look at the evidence that you have, and then they will make a decision on it. Okay. If you're already in proceedings, you will file a case with the immigration court. Once again, they will schedule you for what we call an individual hearing, which is the main hearing, the final hearing. You would go to that hearing, and once again, you will testify, and then the judge will look at the evidence in the record, and then he will make a decision on it. If it gets denied in immigration court, you would have a chance to appeal it. Okay, you would appeal it to what we call the Board of Immigration Appeals, which is the BIA, and then they will look at everything and see if the judge, they'll look at everything and see if the judge made an error in denying your asylum application. If the judge did, they could remand the case, and they could send the case back for the judge, or they will reverse the judge's decision, and then you'll be able to get an asylum. If they do agree with the judge, you can further appeal it to a circuit court. It gets more difficult as you go on, but sometimes you would have to fight. So basically, that's what happens if your case gets denied. For waivers, if it gets denied, you get a chance to appeal that denial. So you file what we call an I-290B appeal, and then it would be reviewed. The denial would be reviewed, and if it warrants, they will reverse that denial. So basically, that's what happened. If you file a waiver and it gets denied, you get a chance to appeal it. Hopefully the appeal turns things around for you. If you file an asylum, depending on where you file it, if you file it with the USCIS and it gets denied, the case will be referred to the immigration court. With that one, you don't get a chance to appeal it with the USCIS. If you file it directly with the immigration court and it gets denied, you get a chance to appeal it to the Board of Immigration Appeals, and then from there you get a chance to keep fighting on. Hopefully that answers the questions on what happens when an asylum or waiver gets denied.
Thank you very much, Attorney Kwasi. Yeah, and this is very important because it's not just getting here, and we keep receiving calls from people that say, "Hey, I would like to get a work permit," but yeah, okay, absolutely, we understand that you want to get a work permit, but you have to have a case. You have to have a case that is pending and that the United States considers as a case that you need an authorization to work. So that's one of the things that people need to clarify. Is not just getting a work permit because you are in the United States. It's more than that. It's having a pending application that allows you to have a work permit meanwhile the application is pending. So that's why you need to talk to a good attorney, like Attorney Kwasi Bediako. And the phone number is 216-279-3984, 216-279-3984. I am 17 years old, crossed the border as an unaccompanied minor. I am from Honduras. I surrendered to immigration on April 7th, and I got my cousin to sponsor me, and I was released on May 15th. Now, my problem is that I turned 18 years old in October this year, and immigration told my cousin that when I turned 18, I no longer have the protection of my cousin. What options do I have when I turn 18 years old? I also need to add that my mother remarried and lives in France, and my dad has been illegally in the United States for 18 years.
Okay, that's a really, really good question, and this is for we have as we keep getting a lot of unaccompanied minors coming in. Basically, you're an unaccompanied minor if you're under the age of 18 and then you come into the U.S. without any guardian. Okay, that makes you what we call a UAC, or unaccompanied alien child. In this case, the good news is once you're a UAC, you are always considered a UAC, which means that you can file an asylum, and even if you're in proceedings, hopefully you're not, you didn't mention that, but even if you're in proceedings, you can file your asylum with, the proceedings should be terminated, and then you can file your asylum with the USCIS. You get a lot more protections, and no, yes, technically you are 18, you become an adult in most states, but you still get some protections because you are considered a UAC even if you turn 18. Another important thing is you may qualify for what we call an SIJ, okay, a special immigrant juvenile. And depending on what state you live in, some states you can only apply for that until you're 18, some states until you're 21. Either ways, your cousin, I believe, can seek custody of you, okay? Because it sounds like your mom is married, she's in France, so she's not in your life, probably not providing for you, okay? And you said your dad has been in the US for 18 years, but you live with your cousin, which means your cousin is the one who's providing for you. And I'm not sure what kind of relationship you have with your dad, but you qualify for an SIJ if you've been abused, neglected, or abandoned. Okay, in most states, you probably qualify as an abandoned child, given that you live with your cousin, your mom is somewhere in France, she has a new family, and your dad is probably somewhere that you don't live with, and he's probably not contributing to you. Depending on what state you are in, I know some states like Ohio, it's 18 years, Tennessee is 18 years, Mississippi is 21, Maryland is 21, California probably 21 also, Massachusetts 21, Alabama is 19. You're still under the age of 18, so if you're in any of these states, you can call our office and we will probably be able to work with you. Your cousin should go to a state court, okay, and then seek custody or guardianship of you. In addition to those custody or guardianship, you should ask the court to make a finding that you have been neglected or you've been abandoned by your parents, okay? If the state court agrees to make these findings, you become eligible to apply for what we call an I-360 based on SIJs. If the I-360, once you get that state order, you have to file for the I-360 before you turn 21. Okay, an SIJ means a special immigrant juvenile. You have to file the I-360 before you turn 21. And once you get this order, you file the I-360 and it is approved, you're able to get a work permit, and in a couple of years, hopefully your priority date will become current. Let's say 3-4 years from that day of approval, from the day of filing the 360, and hopefully 2 years from the day of approval, you'll be able to apply for what we call a green card or the adjustment of status. Okay, but first, the first step in that is you have to go to the state court. Your cousin must seek legal custody of you in the state court. Okay, and then hopefully the state court also makes those findings that you've been abandoned by your parents, and so you need to be with your cousin, where you have someone legally taking care of you, and then you can use that order to seek for an I-360 SIJ. Okay. Other than that, even though you may lose some protections when you turn 18, once a UAC, always a UAC. Hopefully, if you're still within the 1 year, you can apply for an asylum also.
Okay, and so it doesn't matter that the dad is in the United States of America?
No, it does not, and it doesn't matter. If assuming he lived with his dad could have been the one to seek guardianship or custody of him, but since he lives with his cousin, it's really important that that will be a defendant on the case. They will just have to serve him the papers. He'll probably have to show up and defend himself if he wants to. But this is a really good case. The facts make a really good case for an SIJ, special immigrant juvenile.
That's perfect. Thank you very much, Attorney Kwasi. And don't forget that the phone number is 216-279-3984, 216-279-3984. Okay, so next question we have here is, hi, I received an RFE about my I-765 because my EAD was kind of new, but I lost it. I sent the information, but it looks like USCIS didn't receive it. What can I do to keep this case on? I don't want to lose my $410.
Okay, that's a really good question. It's an interesting one. So always, as we always say, always use an attorney. Okay, it's important. You avoid little things like this. It might cost you a little more, but you will avoid losing your $410. That's one. And two, if you're still within, usually when you get a request for evidence, which is an RFE, as they said here, when you get a request for evidence, they give you a time frame where you have to respond. So let's say you get it today, they may give you 87 days. Usually it's 80, that's about 3 months, right? 87 days. So if you're still within that time, I would resubmit the documents. Okay, just make sure you're sending it to the right address. Make sure you're sending to the right address, because they give you an address that you have to send the paperwork to. Any additional evidence that you have to submit, they'll give you an address to send it to. If you are still within the time frame of the RFE, the request for evidence, I would resubmit the paperwork that I sent that got lost. When you mail it this time, just make sure you send it with some kind of either FedEx, UPS, something with a tracking number so you can track it that it's been delivered. Okay. If you're outside that. If you're outside the period, the time frame they gave you to respond to the RFE, let's say if it's a couple of days, I would still resend the paperwork. If it's been weeks since, if it's been weeks outside the time frame where you have to respond to it, unfortunately, your case will probably be denied, and you should start putting things together to refile your case. Okay. Unfortunately, you didn't give that information, but depending on where you lie on the time frame scale, is it within the time frame given to you for the RFE, or are you outside? If you're within it, I would just resubmit the paperwork. Okay, and then just make a notice on there, let them know that you tried to submit it and then it got lost, so you're resubmitting it. If you're outside, I would just get ready, prepare my 765 application, and hopefully refile it. And this time you have everything that they need, so refile it and file it well, and then hopefully it will be approved the second time.
Okay, thank you very much. And if this is going on, and my EAD is pending, let's say I have an asylum pending, I have a U visa pending, or I have a TPS pending. If this EAD is about to be denied, can I file it again for the same kind of case like the asylum, or can I file another one for the TPS?
So the thing about the EADs is everyone has different requirements. So let's say if you have an asylum pending, you have a TPS pending, you can apply for EADs under both of them. They won't stop you. The problem is you just be paying extra fees. So if you don't mind the money, you can apply for EADs under both of them, because both of them would have different requirements. Okay, if you get if you get, let's say, the EAD under the asylum first, they're not going to deny the TPS EAD because you got an EAD under asylum. They will, if you qualify for the TPS also, they will grant you that. It depends on the case, but oftentimes it's advisable that sometimes you file these to, because for instance, a U visa, right? It takes years and years to get a U visa work permit. Okay, so let's say you have an asylum pending, you have a U visa also pending. It's advisable to file under both of them because you would probably get the asylum first, so you can get your driver license, you can get a social, you can work while you wait, let's say a year or two for the U visa EAD to be granted. So yes, can you file both of them at the same time? Yes, because both of them have different requirements. But as always, you want to look into it, see, okay, if I already have this one, do I need this one also? Okay, let's say you have an asylum, it's 5 years. Okay, the next one that you're going to file will only be valid for 2 years. Do you really need it? Do you understand it? So you have to weigh and see, do you really need to file both of them? There are certain cases where it makes a lot of sense to file them, like you have a U visa, you have an asylum, it makes a lot of sense to file both. But there are certain instances where it wouldn't be worth it because one would probably give you only 3 years or 2 years of work permit, and you already have a 5-year work permit through one. So you might as well go with the best one.
Yep, that will be the best option. Thank you very much, Attorney Kwasi, for this information. Don't forget that you can call the phone number 216-279-3984. 216-279-3984 is the phone number that you can call to talk to the attorneys in the law firm of Margaret W. Wong and Associates. The next question is, hi, once the 212 waiver is approved, what is the next step? Do I need to go back to my country, or can I do it in another country? I fear going back to my country. Can I go like to Mexico?
So this is a really broad question. Generally, once the 212 waivers is approved, probably the next step is to get the other waivers, which is probably be a 601 or depending on. So can you go to a different country? You can, but it's always it's a gray area. You're from Mexico. Why would you want to go somewhere else to go get it done? That might affect the outcome of your case and all of that. But yes, you can. You can go back to your. I fear going back to my country. Can I go? Yeah. Why do you fear going back to your country? Did you apply for an asylum? Is there a reason? Generally, you have to have a reason, for wanting to go to a third country. And the issue is, if you apply for an asylum, or if let's say if you apply for an asylum, hopefully you didn't. But there's just an example. If you apply for an asylum and you think you can go to a third country, then they might say, okay, you have no fear of going back to your home country because there's this country that you can go to and get things done. So yes, the 212, and to go back to your question, the 212 is just to allow you to reapply and come back to the US. The 212 is a separate waiver. It's totally separate from the 601 or the 601A and all of that. So the 212 is just after you've been removed or you've left the country, it gives you permission to seek readmission into the US. So that's just one waiver. And that's the thing about the waivers. You should always use an attorney if you can, because it's complicated. It's really tricky. There are little nuances in the law that you might not catch. Okay, the 212 it just allows you to reapply for admission to the US. It doesn't waive other inadmissibility issues that you may have. Okay, so you said, how long is it going to take? It's going to take a while. Okay, maybe a year, maybe a year and a half, maybe faster. If you're unlucky, maybe 2 years. But generally, it makes sense to use a lawyer in these kind of cases because if you're already applying for a 212, that means you likely have some kind of either like a PEMBA or some kind of removal order or some kind of expeditious removal that usually means your case is complicated. Okay, which means you should talk to a lawyer. It makes sense to speak to a lawyer. Even if you don't use a lawyer, you're going to need someone to help you navigate these complexities. So the 212 is just one step. It's just one of the many steps that you need to do if you've been removed from the US or if you've been here for over a year and then you left and you're trying to come back. The 212 is just one of the steps that you need to do in the waiver process. So congrats on getting that 212 approved. There's still more work to be done. and it's advisable that you use a lawyer in that step.
Yeah, and people don't. I mean, all people need to know that these cases take a while. So it's gonna be maybe the wait for a 601. It could be like probably 1 year, 1 year and a half. If it's a
It could be.
601, because if it's a 601A, it's gonna take like 2 or 3 years,
Yep.
maybe
Cool.
more. So it's just be patient, be good, don't do anything that you shouldn't do in the United States, and keep the good work in this country. Um, Last question for today, attorney. Hi, I heard that there is a parole for Honduras. Is this true?
So there are humanitarian paroles for a lot of countries, okay, but qualifying for it is another thing. So is it true? Yes, there's some kind of humanitarian parole, but it's you have to see your eligibility. Okay, we have to look at your file, see what your circumstances are, see if you qualify for it. But yes, there's some kind of parole. And the question is a little broad. There is parole, but depending on what are you using the parole for? Do you understand it?
Yeah, I think this person is asking more about, the Venezuelans, Nicaraguans, Haitians, Cubans, people from Ukraine uh, have filed for the humanitarian parole. But I
Right.
think this one that this person is saying is more related to the reunification.
The reunification one, right?
Yeah.
So I believe there is that. I'm not sure if it's for Honduras also, but I believe there's. So the whole point about the reunification parole is for humanitarian purposes, even if there isn't like a clear cut reunification parole for Honduras for humanitarian purposes, there may be some kind of parole that the person may qualify for. Okay, but it's humanitarian, which means that you have to show some kind of hardship. You have to show that you really, really, really need to, get this parole. You really need to come to the U.S. We have to probably look at the person's circumstances and then see if the person will be eligible to apply for some kind of humanitarian parole. Because generally there are different kinds of paroles, and although the person doesn't specify here, it's probably going to be one of those humanitarian paroles that the person will be looking at if the person should be able to apply for anything.
Okay, well, our time is up for today. So thank you very much for all of the answers and for sharing the knowledge, answering very, very accurately each one of them and with a lot of details. So thank you so much, Attorney Kwasi, for having us
Thank you,
today
Juan.
and looking forward to see you soon.
Thank you. You take care, and it's good to see you.
Thank you. And have a good lunch. And for everybody who has joined us today, don't forget the phone number is 216-279-3984. 216-279-3984. Attorneys in the law firm of Margaret W. Wong and Associates. Thank you so much. Have a good lunch and see you next time.